Day 38. Trump's defense strengthens with expert witnesses. States monitor bid faces rejection. In the ongoing New York fraud trial against Donald Trump, recent developments have brought forth contrasting perspectives on the financial impact of Trump's alleged misstatements. The defense bolstered its case by presenting expert witness Robert Unell, who challenged the state's analysis, claiming that Trump's misstatements cost lenders $168 million in lost interest. Unell contended that the state's interest rate analysis was inaccurate and did not reflect real-world market conditions. Despite Unell's testimony, Judge Arthur Engoron interjected, emphasizing the principle that with less collateral for a loan, the risk increases, leading to higher interest rates. This exchange highlights the continued contention over the financial repercussions of Trump's actions. Judge Engoron persists in denying Judge Barbara Jones the stand. The defense's persistent attempts to subpoena former Judge Barbara Jones, the Trump Organization's independent monitor, were denied by Judge Engoron. Trump's attorneys sought Jones's testimony to address ambiguities in her reports related to the New York Attorney General's fraud accusations against the Trump Organization. Despite the defense's argument that calling Judge Jones would provide clarification, the judge maintained that such a move would pose a dangerous infringement on court immunity. This ruling adds another layer of complexity to the trial, underscoring the legal battles beyond the direct examination of evidence. Trump easily qualified for a wealth management bank loan. In a crucial turn of events during the trial, the defense's commercial real estate expert, Robert Unell, strongly contested the state's claim that Donald Trump employed fraudulent tactics to secure favorable loan rates through Deutsche Bank's private wealth management division. Unell asserted that Trump undeniably qualified for commercial loans via the bank's private wealth group, dismissing State Attorney Kevin Wallace's contention that Trump had deceived the private wealth group to obtain these loans. Despite Wallace suggesting that submitting an allegedly false financial statement might disqualify Trump from the private wealth division, Unell, having reviewed Deutsche Bank Managing Director Dave Williams' testimony, emphasized that he found no evidence indicating Trump's ineligibility for the private wealth management group. He stated, "I have not seen or heard any evidence that President Trump did not qualify for the private wealth management group." Prior to Unell testimony, Deutsche Bank Managing Director Dave Williams stated on a day earlier that Trump easily met the bank's $100 million net worth requirement for high net worth individuals. This testimony adds a crucial layer to the debate over Trump's qualification for the loans, challenging the state's narrative of fraudulent practices in accessing favorable loan rates. Bank and judge agreed on Trump's net worth. In a bold revelation during the trial, defense expert Robert Unell highlighted a striking agreement between Judge Engoron and Deutsche Bank concerning Donald Trump's actual net worth. Despite the bank's valuation services group undercutting Trump's net worth estimate by approximately $2.4 billion in 2013, Deutsche Bank officials proceeded to loan him millions for 3 of his properties. Unell pointed out that, while this significant discrepancy might be deemed unusual in other contexts, it raised no concerns for the bank. Judge Engoron, known for his decisive rulings, had earlier emphasized the gravity of the New York Attorney General's evidence, stating that a misstatement of at least $812 million cannot be considered immaterial even in the realm of high finance. The courtroom exchange underscores the contentious nature of the trial, with Engoron swiftly cutting off Unell's attempt to delve further into whether the discrepancy fell within the range previously determined by the court. What is the real value of the Mar-a-Lago Club? The ongoing trial against Donald Trump has unveiled compelling evidence regarding the valuation of his Mar-a-Lago social club. As a reminder, documents entered into evidence reveal a stark contrast between Trump's claimed value of $517 million in his financial statements and the much lower market value of $27 million agreed upon by his tax representative in 2020. Judge Engoron had previously determined a significant overvaluation of Mar-a-Lago, estimating it to be at least 2,300% higher than its appraised value by the Palm Beach County assessor. The documents also shed light on the Trump Organization's awareness of the valuation discrepancy, with former Trump Organization VP Raymond Flores testifying that Trump's tax representative withdrew an appeal, conceding agreement with the property assessor's valuation. The trial further exposed internal communications, including an email exchange where Trump's tax broker, Michael Corbiziero, advised against classifying Mar-a-Lago as a residence due to adverse tax implications, contradicting Trump's earlier claim that he valued it as a private residence. Corbiziero stated, "Currently this property is assessed as a private club with the current assessed value at $359 square feet. This is significantly lower than neighboring properties valued almost 10 times higher." Despite this, Corbiziero insisted against classifying Mar-a-Lago as a residence due to tax implications, as outlined in the forwarded email to Eric Trump and Weisselberg. These revelations provide a nuanced understanding of the intricacies surrounding the valuation and classification of Mar-a-Lago. Trump is not immune from civil lawsuits over the January 6 Capitol attack. In a separate legal battle that is unfolding in Washington, D.C., a U.S. federal appeals court ruled on December 1, 2023, that Donald J. Trump can be sued over the January 6, 2021, attack on the U.S. Capitol. This decision by a U.S. federal appeals court rejecting Donald Trump's claim of immunity in civil lawsuits related to the January 6, 2021, Capitol riot signifies a legal setback for the former president. The court ruled that Trump, when instructing his supporters to march to the Capitol, was acting in his capacity as a presidential candidate, and not in an official presidential capacity, thereby negating immunity claims for his political actions. Chief Judge Sri Srinivasan, along with Judges Gregory Katsas and Judith Rogers, emphasized that Trump could attempt to prove he acted in an official capacity as a defense in the lower court. This ruling opens the possibility for Trump to face civil lawsuits from individuals, including police officers and lawmakers, injured or threatened during the riot, and marks a pivotal development in his legal challenges, which also include criminal charges and investigations. In conclusion, as the trial progresses, the state attorney, Kevin Wallace, is expected to continue cross-examining Unell, focusing on the potential fine against Trump. The state seeks to use the lost interest analysis to justify the fines, or disgorgement, for Trump's alleged ill-gotten gains. These developments reflect the multifaceted nature of the trial, intertwining financial analyses, legal battles over witness testimonies, and the ongoing efforts to determine the extent of Trump's liability in the alleged fraud case. Thanks for watching. If you like it, comment and hit the like and share buttons. Subscribe for future videos.